seeing that is the tail end of what happens in courts day after day. You know, when crime isn't prosecuted properly and criminals are let out, or criminals, you know, aren't caught in the first place, that's what happens. And society seems to get that and be really worried about victims like Julmar. But for victims like me, every day, or yourself,
yes,
the public aren't even aware. They think the prosecution are there for victims and fighting really hard. You could see today, the police didn't even put the case together properly. Their investigation was shite. There were holes in it left, right and centre. And I think, my goodness, what does the OPP take away holistically every day in cases across Victoria, day after day, you know, because crime is by state. So in each state, all these prosecution services, what do they take away holistically? I'm just not knowing what they do for their professional development, how they keep, you know, their employees sort of buoyant and excited about what they do. I mean, they're just filling out pro formas and turning up to court and opening up their laptops at the bar table and saying nothing compelling, nothing intelligent. And victims aren't even in the courtroom to assess it, because remember, the police say, oh, you don't need to be there, it's too traumatising to be in the courtroom. You stay home, we'll tell you what happens. So no one is there assessing this day after day. Only people like me, and that's rare because you're not going to turn up to court unpaid every day to assess how the OPP are running their prosecutions. But the defence know. Criminal lawyers like my husband every day know exactly how poorly the OPP are doing their work, because my husband comes back with happy clients every day. They're quite happy. They think he's a brilliant criminal lawyer. Now, I mean, I don't want to criticise my husband. I think he's pretty good, but I would love to be opposed to him at the bar table for victims. Come on, let's get the show on the road. Let's admit what the legal system does to victims every day. But it's not about women being braver, or, you know, men that were boys and were abused years ago becoming braver. We've been brave for years. I've been burning my bra for how many waves of feminism? I'm 45. My mum was a feminist. My grandmother was a feminist. How many more waves do we need to say, where is the victim in this courtroom? They're not there. Where's their representative? They're not there. I can't be any clearer, and I honestly feel like burning my practicing certificate. You know, in the Supreme Court today, that's where I was admitted in 1999, with the hope that I'm there to elicit the truth and bring justice to my clients. What the hell has happened to that? Or was I just an idealist idiot from the outset? I mean, I don't know what the practice of law is in crime. And then you have all these aspiring young law students that come through our office, you know, to do work experience. And I say, what do you want to do? And they go, oh, we want to shadow John because we want to be criminal lawyers. I think, criminal lawyers? What do you mean? What do you want to be a criminal lawyer for? You're a young woman, like what? So I think there's a real disconnect between the reality of practice of law and being a responsible citizen that has empathy. And I think if that chasm gets too great between the two, there is a very real danger there for lawyers and for society, because I just think to be a great lawyer means you're actually undoing the good of society, and that's what's happened today in the Pell case. I mean, if he gets away with this appeal, it would just be a travesty. But then when you look at it and what the police did, you can't really blame defence for doing what they've done. They've raised cogent legal arguments. So until we get a great legal team for the victim, it is not worth the victim going through this process, is my point.
I'm going to make a quick comment here. In my own case, my abuser suicided. I didn't get a chance to take him through the court process. Yeah. One of the fears that I have is during the civil process, if it gets to the door of the court and it doesn't mediate, then it is likely that my testimony will be possibly challenged and questioned in a civil matter. This is in the state of WA. For those who don't even have the option of a criminal trial. What are your thoughts on that issue?
I think it's a big problem, because you'll find that a lot of victims, when they don't get justice in the criminal justice system, which as we've found is 99%, and that figure I should also qualify, that has come from Rob Hulls directly, who's the Director of Centre of Innovative Justice, who was our previous Attorney General in Victoria. So I think it's coming from a learned source. So it's 1% conviction rate. So people in your shoes from the 99% camp will then go to the civil suing someone in their respective court, the district court or the county court. And this is a very real problem. So we've had changes since the Royal Commission to assist people in your shoes when they're going to sue. So we have abolished the statute of limitations. Huge tick. Brilliant, right? We've also decided, though, that the passage of time is the first argument you're going to be up against. Because even though that was abolished, the statute of limitations, so you can bring an action at any time, the problem is the defendant's going to say, look, I've got ABI because of the passage of time. How many arguments do we hear today in the Pell case about the passage of time and memory? Now, that's the problem, because if they say, look, due to the passage of time, the defendant is too prejudiced to actually be able to defend an action against you, there's the problem. It's the same problem but dressed up in disguise. So even though they've abolished the statute of limitations and will let you pay your filing fee of $1,000 to lodge your suit, very first hearing, it's going to be about the passage of time still. So that's a huge problem. Then we've had changes where, say, for example, your abuser is linked to an organisation. Then what we had is that people need to nominate and come forward and say, okay, I'm actually the entity that you can sue, because for so long you couldn't sue the church, etc., etc. We know those arguments, I won't repeat them. So you think, oh, well, that's a huge advance as well. But again, the problem is you still need money. As a victim, you still need money, and how many, when they've lived a life that may have a criminal record, there might be addictions, self-harm, all those things. How many hold down a great, highly paid job enough to fund a court case that, if you were to file, you're looking at a 2 to 5 year thing. Depends on how much they want to play with you, how long they're going to muck around with the civil procedure rules, and be in breach of them. This is what people do all the time. Delay, adjournments, Even in my case, what happened was there was a trial set. I won before the trial ran, was actually given a judgment in default. But then the minute that I won, the trial dates were taken, because that's what the court does. They think, oh, well, there's not going to be a trial, we'll vacate those dates. But they didn't wait till the appeal. And then what happens is the defence was reinstated because the lawyer created a fiction that he was the one that mucked around. It wasn't the defendant's fault, it was my office was in error, is what his lawyer said. And because of that, the defendant couldn't be prejudiced. So what happens? They said, sorry, well, we've lost those dates, now we'll set a new trial. Another 9 month delay. Now, to me, my life was on hold. I couldn't exist like that. But to the court, it's just, oh, well, you're not that prejudiced, Ms. Irwin. We've just rescheduled a new trial. So it's the trouble like that. It's the way the court doesn't understand how a victim lives. And you could hear it today coming through in the Pell case. You could hear the same themes coming through, like when, the judge said, well, why wouldn't one choir boy warn the other choir boy? I mean, this is going against, I thought we're better than that. I thought we've learned from the Royal Commission why people don't tell, why it takes them so long. But it seems that it's like, oh yes, we're happy. We spent $540 million on the Royal Commission to get really smart about survivors. We had people like Carolyn Quadrio come and give evidence about sleeper victims and about the trajectory of victims and how long it takes. And but when we have another case, we just forget all about what we learned in the Royal Commission. We'll go back to 1980s thinking, why didn't you, Mr. Choir Boy A, speak to Choir Boy B? And this is the prejudice. This is the problem. We've got inbuilt prejudices inbuilt into the criminal law narratives that these judges work by, and it's not an individual judge's fault. It's just that there's so many years and layers of this stuff that it's really hard to cut through, particularly when today the prosecutor really did not have social science arguments on the ready, and he should have. He should have been able to tell the judges today why choir boys didn't tell or why certain things were so. He just didn't seem to have a clue. And I thought, my goodness, I was ready there. I could have said 1,000 things. And that's why it's so frustrating to be a lawyer and to know. If I was just a member of the public that didn't really know and just thought, oh, police are doing a great job, then I might just be deceived and be none the wiser. It's more difficult to know, and it's more an insult to be in the know. I'd almost love to be ignorant, as they say, ignorance is bliss, and then just think, oh, look at all these learned people doing the best they can. It actually was so embarrassing today. I'm really concerned that that's the best the state can do for a victim.
Ingrid, one of the issues that a lot of historical survivors of institutional abuse are going through at the moment is because the redress scheme has been gutted and destroyed by a combination of factors, which are probably too complex to go into now. We're saying to victims, and not to use a redress scheme, not to use towards healing, not to use the Anglican Kiora scheme, but to always go down the path of civil litigation if that's possible. We know there are some great lawyers that are doing civil litigation on a no-win, no-fee basis. One of the issues that seems to be happening amongst the survivor community who are not as who don't have the education to understand the legal process is that sometimes what is promised is not delivered. Figures are thrown around that can make someone think that their life will change radically, and then that figure is changed to something which is far less than the castles in the air that some people paint. What would you advise survivors who are going through any legal firm in regard to a no-win, no-fee basis?
Yes. I'll say it's a choice between two evils, really. You've hit the nail on the head. I actually now am doing a backflip, and I never thought I'd say it. The redress scheme capped at 150. We've all been critical of that. They give a matrix, to assess abuse. They say one person's abuse is worse than another's, which is exactly the antithesis of what we learnt in the Royal Commission. It's about the after effects of abuse. So it should never be about how many times you were raped or did they use a body part or an object. All of those things are just ridiculous to put in a matrix. It is ugly. We don't do that for PTSD of war veterans. We don't ask a war veteran, how many people did you kill? Or how many dead bodies did you see in the trenches? Oh, no, you never actually killed someone. We don't grade that. We just say, look, your trauma is legitimate. And here's a badge of honour. You can be part of the Anzac Day parade. So I'm very concerned about the matrix. Trust me, I was the number one no camp to the redress scheme. But when I look at it, when I look at the years that you add up of court-licensed abuse, re-traumatisation, needing to recall all of your abuse, going through the psychologist and being heightened all the time, then being anxious about delays, having your life put on hold, just basically having a life that moves between phone calls between your lawyer, your psychologist, because you need to establish that there's been psychological, harm, all of that stuff. You just end up, that overtakes your life. If you want to do that, you can kiss goodbye 2 to 5 years of your life just in legal process and hanging in the balance. Now, when I look at that, and then I look at what legally you can take away, sometimes the price is high, like in terms of the win, but so much of that will go on your legal fees. Okay? It's no win, no fee. That means you win, you pay. So what you come away with as a survivor often is not much more than 150. It might be just under 100,000, it might be 80. It might sit around what you could have actually got under VOCAT. Now, that is embarrassing as a lawyer to say that, but I would prefer to say that and get someone a swift amount that is just piddle piss. I mean, really, 100,000 is like ridiculous. It doesn't even cover a year of the trauma of abuse of what you've walked around with. You should times that by each year you've lived almost. But the thing is, it's not realistic. That is not what people are coming out with day after day. There have been some great cases that bandy about those figures, the $1 million settlements and so. But really the reality is a lot of people settle somewhere midway in that process of civil litigation, somewhere in the mediation range. And you still need to feel good about that. And when you walk away and say, okay, well, after 3 years I settled at a mediation or, I accepted an offer somewhere along the way, and it's sitting around the same as what you could have got with no financial outlay, it's sometimes starting to look ugly. And I think that's why that redress sits at that 150.